Number 79, Robert L. Pierson et al. Petitioners versus J. L. Ray et al. And number 94, J. L. Ray et al. Versus Robert L. Pierson. Mr. Ratcliffe.
Mr. Chief Justice, may it please the Court. The complaint here alleged two causes of action, one based upon Title 42, Section 1983, based upon the 1871 Civil Rights Act, and the second cause of action was a common law action for false imprisonment. The defendants in each of these causes of action were the police officers and the convicting magistrate who had incarcerated the petitioners herein, petitioners being one Negro and three white Episcopalian ministers who were arrested in the bus station in Jackson, Mississippi. At the trial on the damage question, which is presently before this court, before Judge Mize of the Southern District of Mississippi, before him and a jury, there was a verdict for the defendant. That is the respondents here. The petitioners appealed to the Fifth Circuit, and the Fifth Circuit reversed because of errors made by Judge Mize with regard to the admission of evidence. However, in reversing, the Fifth Circuit dismissed the case against the magistrate, respondent Spencer here, and insofar as the question of damages was concerned, set forth a rule on the new trial which indicated that if there was a finding that there was a plan and purpose to be arrested, then the petitioners here could not recover in the new trial. It was on those two issues mainly that we came to this court, and upon our petition, certiorari was granted by this court. They are raised in the cross petition, Your Honor, by my colleague, but they're not raised by us. Now, very briefly, and I will try to be very brief because I'd like to report questions of law and novel to this court. Very briefly, the facts are as follows. The General Convention of the Episcopal Church, the Triennial General Convention of the Episcopal Church, was to be held in September 1961 in Detroit. The petitioners here, particularly petitioner Reverend John Morris, who is the director of the Episcopal Society for Cultural and Racial Unity, thought it would be a great witness for their church to hold a prayer pilgrimage beginning in New Orleans and ending in Detroit, and on the way bearing Christian witness to factors in various communities going up generally the Mississippi Valley on the way to Detroit, with intention of stopping at places like Sewanee and Dearborn, Michigan, as well as Jackson, Mississippi. And they set out by bus from New Orleans and arrived in Jackson and spent the night on the day before the arrests were made here at Tougaloo College. There had been, of course, some publicity in the papers and the newspaper and the radio about their activities. But the next morning, when they went with tickets for Continental Trailways bus to Chattanooga, and they had not given any publicity, and there is nothing in the record which indicates that anyone knew when they were arriving at the bus station. And the fact of the matter is, the record reflects that when they did arrive at the bus station, no one was waiting for them. The police testimony is very clear on that point. They arrived quietly in taxi cabs. There were two police waiting on the back ramp at a bus station. The police went around the back way and met the priests as they walked through the main entrance of the bus station, past a police stanchion right in front of the entrance to the bus station, which said, "White only by order of the police." As they went into the door of the bus station, Father Jones, one of the petitioners here, heard one of the officers say, "Shall we get them now or shall we wait till later?" In any event, there were 15 priests in this group, 4 of whom are petitioners here, walked through the entrance and started toward the coffee shop a few feet inside the bus station. A few of them, of the 15, did actually get into the coffee shop, but at that point, one of the 2 police officers, either Officer Nichols or Officer Griffiths, 2 of the respondents here, halted them and made them those that come in the bus station come back, and they halted the whole group and were told to move on. At this point, one of the priests said, "We are on our way to Chattanooga. We have tickets, and we wanted to, it'd be a long trip. We wanted to have coffee or sandwich or something before we take off on our trip." The police officer said, "Move on." With no moving on, they were arrested. And not being told, and the record doesn't reflect why they were being arrested at that point, or what they were being arrested for, or why they were told to move on. But in any event, a few moments later, the respondent Ray, the Deputy Chief of Police of Jackson, Mississippi, and at that time the captain of the police, came in the station and immediately walked up to these people and told them to move on. Not seeking information from the other police officers, they were already under arrest. In any event, the comedy went on, and he told them to move on, and they repeated the same thing. They wanted to have a sandwich before they took off for Chattanooga. And he, at that point, not moving on, he also arrested them, and they were then taken off in the traditional Jackson paddy wagon to the jail, and where they stayed 2 days later when the case was then tried before Magistrate Spencer, who convicted them and sentenced them to the maximum sentence of 4 months in jail for the offense that they committed, as well as a fine which was put upon them. All the petitioners here remained in jail for at least 7, and Father Jones, I think, something like 17 or 18 days, the reason being that bail was coming from various communities to help bail them out, and took at least 7 days to get bail, and more for Father Jones. In any event, after they all were released, they went on to the convention, they appealed the case. And in Mississippi, the first appellate procedure is this de novo trial. And at the de novo trial of Father Jones, the first one tried, after the prosecution's case was in, motion was made to dismiss, and the judge presiding at that level dismissed the case on the grounds there was no showing of a violation of the statute. It was there, and all the other cases were accordingly null prost. At that point, shortly thereafter, the complaint was served in the case before us, and was tried, as I said before, Judge Mize. Defendant's verdict, we appealed to the Fifth Circuit as indicated. Now, the first issue that I would like to spend some time on is the one in which the Fifth Circuit dismissed the action against the convicting magistrate Spencer, one of the respondents herein. Now, it is our position that this was an error for many reasons, and I would like to go into that in some way. The statute, of course, 1983, the opening words are every person, so that on its face, anyone who violates 1983, whatever his position in life may be, is liable. The question then is, are there any limitations in this broad language which should be a guide to any court considering the matter? Prior to the well-known case decided by this court in 1951 of Tenney against Brandhoff, there had only been one case interpreting this point, to the best of our knowledge, and that was a case entitled Picking against the Pennsylvania Railroad, a Third Circuit case, which held in the manner that we are requesting this court to hold. That is, there was not an immunity for a judge who violated the statute. However, Tenney against Brandhoff set off a whole new line of cases, which are referred to both in the opinion of the court below and I'll refer to in my worthy opponent's brief. And in fact, I think this court has either accepted or is considering certiorari in two related cases involving a Dombrowski case and a Bowers against Heisel case on related questions. Every circuit deciding the case since Tenney has decided in a manner which we consider in error in interpreting the statute. Now, Tenney involved...
As to judicial immunity.
Yes, Your Honor.
You're referring now only to this
I'm only referring
judicial
to
defense.
I am not concerned with any other questions, Your Honor.
Yeah.
Now, Tenney involved, of course, a state legislator of the state of California, and who was sued under 1983 by someone claiming that Tenney had violated his rights. Now, under Tenney, the majority decision was based upon what was considered to be the ancient immunity of legislators. And there is no other basis for that decision as set forth in the decision. Oddly enough, this, of course, reason is irrelevant, because if the 1871 Congress wanted to specifically include state legislators, the fact that there may have been an ancient history exempting legislators would be of no consequence whatsoever. However, the majority decision in Tenney is decided solely on the basis of the ancient history of immunity to state legislators. Now, there were at least two other ways in which that case could have been decided coming to the same conclusion, which would have, however, been more accurately a reflection of the law. And I would like to dwell on those for a moment. The first one, of course, concerns the legislative history of 1983. When Congressman Schellenberger of Ohio introduced the legislation we are concerned with in the House of Representatives in 1871, he made the following comment, and I read from the Congressional Globe Appendix of March 28, 1871, 42nd Congress, first session. He said as follows: "My first inquiry is as to the warrant which we have for enacting such a section as this. The model for it will be found in the second section of the Act of 1809, 1866. If I may interpolate, those are the sections of Title 18, 241, and 242, which have been considered by this court in Price, for example, U.S. against Price, for example. That section provides a criminal proceeding in identically the same case as this one, provides a civil remedy." Now, that being so, if the majority opinion in Tenney had followed that thought along and would have turned to Senator Trumbull's explanation in the Congressional Globe of April 4, 1866, when he replied to the veto by the then President Johnson of the 1866 Act, what is now Title 18, 241 and 242, President Johnson referred specifically to the point that came up in Tenney against Branham. And what does he say? Who is to be, and I quote from page 1758 of the Act of the Congressional Globe of April 4th, 1866. Who is to be punished? Is the law to be punished? Are the men who make the law to be punished? Is that the language of the bill? Not at all. If any person under color of any law shall subject another to the deprivation of a right to which he is entitled, he is to be punished. The person who under the color of the law does the act, not the men who made the law. And he goes on in that way. In other words, what he's saying very specifically is that both from the point of view of the intent of the Congress of that period and from the point of view of the analysis of the words of the statute, state legislators were immune under both Title 18-240, what is now Title 18-241, and, of course, under Title 42, 1983. In other words, state legislators are to be immune. But what does he say about judges? In other words, he makes the very distinction that we are trying to make in this particular case. And because, I might interpolate again, President Johnson, when he vetoed this 1866 Act, two of the reasons specifically given by him for his veto concerned the immunity of legislators and the alleged denial of the immunity of legislators and the alleged denial of immunity of judges. Now, we have seen Senator Trumbull, who replied to President Johnson as to what he said about legislators. Now, this is what he said about judges. But it is said that under this provision, judges of the courts and ministerial offices who are engaged in the execution of any such statutes may be punished. And that is made an objection to this bill, referring to this president's veto. I admit that a ministerial officer or a judge, if he acts corruptly or viciously in the execution or under color of any illegal act, may be and ought to be punished. But if he acted innocently, the judge would not be punished. And further on, a judge who acted innocently and not viciously or oppressively would never be convicted under this act. But,
is that what you're contending here? Are you contending, Mr. Eklund, are you contending that the judge here acted corruptly?
We are contending, Your Honor, that the judge here knowingly and willfully as our complaint alleges in paragraph 22 on page 5 of the record, that the judge, so far as the judge is concerned, convicted and deprived the petitioners of rights, privileges, immunities, etc., for the sole purpose of enforcing the segregation laws, customs, policies, and usages of the state of Mississippi.
You contend that that's corrupt?
I would contend that that is what is considered to be a violation, what we consider to be a violation of the statute, deliberately imprisoning someone without any evidence in the record, and that is
not supported by that quotation, is it, that you just read?
I'm sorry, sir.
It's not supported by the quotation that you just read. Your position is not supported by the quotation that you just read.
I would not accept that, Your Honor.
That's what I'd like to know. Just
well, I would say that...
square your position with that.
Let me get back to my quotation. What Senator Trumbull has said here, first of all, of course, if he acted innocently, the judge would not be punished, and we don't dispute, we accept that, of course. And
your
that
problem is what is innocence.
What is innocent? But we also says if he acts corruptly or viciously. Now, viciously is not a word of art, it's common parlance, but I would certainly think that that would apply to a judge who, without evidence, convicted and incarcerated people, knowing there was no evidence, and this is based upon not only what I say about the case and what the complaint says about the case, but the fact that on the first appellate level, the judge who tried the case dismissed on the prosecution's evidence because he said there was no evidence to show a violation of the statute. And we say the record reflects, though that is not important from the purposes of the position we're taking here in this case, that they were convicted because that sign outside the bus station said that anyone who entered that bus station who was Negro was in violation of the law, because that sign said white only by order of the police. And it's hard to conceive of what that means except in terms of anyone other than a white person who enters, or who whites and Negroes who enter together are in violation, and that's why they're arrested, because the testimony of the police here says these petitioners did absolutely no act which could be remotely considered wrong. And unlike the Adderley case, these people had a right to be here. There was no question they have a right to be in a bus station quietly and peacefully with tickets in their hands about to go off to Chattanooga. I mean, whatever the merits of an Adderley type of situation, they don't apply here at all, because these people had a public right to be there. And they were asked to leave not for anything they did, but because that sign outside the door of the station did not permit them to enter the station.
He had jurisdiction. The judge had jurisdiction, did he not?
Yes, there's no question. They were charged under a Mississippi statute, disorderly conduct statute. So that, in that sense, he had jurisdiction, of course. There's no question. But we think that the intent of the Congress of 1871, from reading the Congressional Globe at that time, is so carefully drawn against the sham justice that was perpetrated in the period from 1866 through the period of 1871, that the very kind of conduct that is concerned in this case is the kind of conduct the 1871 Congress was concerned about. They were concerned about the phony justice, the sham justice, the police who arrest and the judges who convict when there is no evidence of any wrongdoing. Absolutely not. Because we have the distinction that we draw, and we think that Senator Trumbull draws that distinction perhaps better than we can, but we just think the distinction is that when a judge does it knowingly to perpetuate an illegal custom such as segregation, then he would be liable. But if he makes a mere error of judgment or is even unacquainted with the law, that would not be any violation of 1983. We're not questioning his right to continue to make errors of judgment. We do question the right to sit, for example, to take a case which I think might lay out the situation. We do question the right of a judge to meet with hoodlums the night before he knows he's going to try a case, and tell the hoodlums, okay, fellas, I'm going to throw the book at these guys tomorrow morning when I try them. That's the kind of case we're talking about. And the decision of the Fifth Circuit and of the other circuits, if upheld, do not permit 1983 to cover a judge under those circumstances. Now, just briefly, every case that has come since Tenney against Brandhoff, even though Tenney was a state legislator case, every case that has been decided by the circuit courts, and there have been several since then, have decided solely on the basis of Tenney. Even though Tenney refers to a state legislator, those cases which refer to judges are given the decision in the same manner as if they have the application to the Tenney doctrine. So Tenney has, in a sense, if you permit me to say so, led the courts astray by an improper analysis of the statutes of 1871, 1866. It is our position that if Tenney had been decided on the basis of the legislative history and the analysis of the words of the statute, the other courts would not have made the mistake. As a matter of fact, Judge Magruder of the First Circuit in Francis against Crafts, which has been referred to by the court below and by our worthy opponents, is a typical case where Judge Magruder in that decision says the statute is very broad, and I am very grateful that the Supreme Court has decided Tenney against Brandhoff because, in effect, it takes me off the hook. And this is precisely what Judge Magruder, who is a very fine judge, has said in a case involving a judge in Massachusetts. So that the trouble has stemmed from what the courts have decided in Tenney. Now, Tenney, I would hope that Tenney would be reconsidered in terms of not the decision, because the decision is correct in light of the statutory history, but it is wrong in terms of the reason. If the right reason is given, then all the other cases that are decided after Tenney become meaningless. And this court then is considering not only de novo from the point of view of an issue that has of the liability of a judge under this statute, but is not faced with the question of decisions made by the lower courts to the contrary. And there is only one decision which has any meaning, and that's Picking against Pennsylvania Railroad. Oddly enough, not one of the cases, with the exception of Bowers against Heisel, which I believe is submitted a petition for certiorari and was only decided a couple of months ago by the Third Circuit, not one of the cases following Tenney...
Is that the one about the prosecutor in New Jersey?
That's a New Jersey state prosecutor, yes. That's the only one of the cases which even makes a brushing reference to the legislative history.
Immunity was extended there, too.
By the Third Circuit, Your Honor. And the Third Circuit there, in substance, said that it was overruling its prior decision in Picking against the Pennsylvania Railroad. Though one was a judge and the other was a prosecutor, and perhaps they might come to different conclusions under the same statute.
Well, didn't the Third Circuit hold there that the prosecutor was entitled to immunity because the judge was entitled to immunity?
Yes, as a matter of fact, that was precisely that reason. That was part of the judicial process, and that prosecutor was part of the process and ought to be immune as a judge. But even there, the court sat en banc in Bowers against Heisel, and there were 4 opinions, either concurring specifically only in the result, and specifically saying that they were not going to go into the question of the legislative history, and 2 that rejected the decision because the legislative history was to the contrary in Bowers against Heisel. In fact, Judge Biggs of the Third Circuit has what we think is the proper analysis of the statute and goes into the legislative history in some detail, whereas the majority of the court there gives in a footnote a brushing reference to part of the legislative history, ignores most of it, and ignores the result of all and says we're deciding the case on the basis of Tenney against Branagh. Now, with that kind of record, we think that there is nothing in the legislative history here, nor in the word of the statute, which sustains the immunity of judges. We think that from what we have said in our brief, that it was clearly the intention of the 1871 and the 1866 Congresses in passing these 2 complementary statutes, that is the Criminal Act under Title 18 and the Civil Act under Title 42, clearly, unmistakably intended to include judges. And the proof of it, we say, is in the fact that persons on both sides of the debate in the halls of Congress acknowledged this was so. They may have disagreed with the virtue or the wisdom of it, but they both agreed. They both agreed that judges were liable if they committed a violation of the Act, in the terms of Senator Trumbull, were not immune.
Is it your argument that every judge who turns somebody loose can be sued and has no immunity?
No, Your Honor. I would say that the only judge who is liable is one who convicts not intending to deprive him of
all
equal...
of them could be sued for it, and you'd have to prove his motive?
Yes, Your Honor, that would be true.
That's the argument. Every judge who tries a person in the United States under this Act can be prosecuted on the basis of that Act. He was convicted of a crime.
On the 1866 Act, if he was shown to be violative of the Act, yes. We say that there was no immunity by the virtue of the office, and that if he violated the Act, yes, he would be liable, or if he, in the civil suit for damages, liable for damages, if we're shown and proved a violation of the Act. It isn't. I mean, of course, people can be sued and improperly sued, but I would assume that there are lots of people who hold important positions in the United States who could be sued.
What about the appellate court judges?
Well, first of all, it doesn't apply to federal judges, Your Honor. The federal judges are exempt by the terms of the statute. It only applies under the color of state law.
I assume it could apply to federal judges.
I don't see how it could, Your Honor. I don't see how it could under the terms of the statute. It does not apply only someone who acts under the color of state law.
Well, would that get the Supreme Court judges of the states?
I suppose theoretically it could.
Theoretically? But
yes.
Actually, wouldn't it?
Well, actually, in the sense that, yes, they could be sued. And
they'd have to try a question of evidence as to how guilty they thought the man was.
That would be so, Your Honor. But I think that I think that is the correct interpretation of the statute. There are lots of people. Take a surgeon who holds a person's life in his hands every time he operates on someone has no immunity, and if a judge acts corruptly or viciously, when there is no evidence and with a deliberate intent to deprive somebody of a right that he is entitled to, I can see no reason why a judge should be put in a position that a surgeon is not.
There are a few defendants who have been convicted who didn't think they were deprived of the right corruptly and brutally by the judge.
Well, that may be true, but in the case before us, Your Honor, that isn't the facts. The fact is at the first appellate level, the case was dismissed because there was no evidence to show a violation of the statute in the first place. And whatever there may be in other situations, we are saying that there should be no rule which grants an automatic immunity. We say there is only... sorry, sir.
My questions do not mean that I'm saying that you're wrong, but it seems to me like that's precisely the correct statement that you've made as to the consequences of your argument.
And Your Honor is correct. That those are possible consequences of the argument that I make, and I would have to face that, good or bad.
What you've just said is narrower than the position reflected by your complaint. As I read it, your complaint does not even allege any motive.
Well, it does to this
extent.
extent. I'm sorry, I shouldn't interrupt.
It does not allege any motive on the part of the judge.
Well,
it says that these people were convicted in violation of their civil rights for the sole purpose of enforcing segregation laws. You don't have any allegation in here about corruption or corrupt motives or vicious purpose or anything of the sort.
Well,
Is that right?
I'm sorry, I would think that if a judge convicts somebody for the sole purpose of enforcing a segregation law or custom, that spells out the violation.
You allege here that a state judge convicted a person for the sole purpose of enforcing the segregation laws, customs, policies, and usages of the state of Mississippi.
That's right.
Usually state judges are kind of supposed to do that unless there's a supervening federal law.
Well, they were convicted under the color of a state law, that is, the disorderly conduct statute of the state, but not because there was any evidence showing a violation of the state statute, but solely for the purpose of convicting and incarcerating these people because the state intended to uphold the segregation, that is, the judge intended to uphold the segregation laws of the state. And if he merely made a mistake of evidence, we would say, no matter how wrong he might be, we would not feel he was liable. But where he does it with the intent, as we say, for the purpose of upholding the laws, we think that spells out the same thing that Senator Trumbull was discussing. The second, I'm sorry, my helmet. Thank you very much.
We get it from your brief. Mrs. Grayson.
Mr. Chief Justice and Associate Justice, with due apology to my opposing counsel, I don't think that this court is the place to argue disputed questions of fact as if they were being argued before a jury. And my position is that that's what opposing counsel has done. They have argued their own testimony or their own complaint, allegations in their complaint, without any reference whatsoever to proof on the other side on what was a jury issue or issues in this case. This is a suit in tort for money damages in 2 counts, first under common law for false arrest and second under 1983. The issues before this court, the jury came in with a decision for the defendant on disputed questions of fact. The issues before this court are not whether those facts were rightly decided by that jury, because it was a jury issue and will go back after this decision to be a jury issue. Regardless of this decision, it has to be reversed and go back for a trial by a jury. The issues in this case are whether or not there is any judicial immunity as a matter of law when there was no proof whatsoever of any corruption or any wrong intent, and whether or not there is a partial or limited immunity to police officers who act in good faith with reasonable grounds to believe, which is a question of fact, with reasonable grounds to believe that the statute was being violated, that they had probable cause, which, as I state, is a question of fact. I therefore will only discuss factual issues to the limited extent of pointing out to your honors that there was a disputed question of fact on the right to the police officers to believe that there was probable cause of a breach of the peace. And in doing so, I hope the court will recall and keep in mind that this occurred in 1961. We must look at the facts in the case in view of the times. We must look at the facts in the case in the view of the mood of the people, of the tenseness of the people in the city of Jackson. In 1961, We must look at the case in the view of what the law was in 1961, and how far the constitutional standards have been changed since then.
Miss Grayson, excuse me.
Yes,
please,
Mr. Justice White.
Did I understand you to say that your claim for judicial immunity here stems from the absence of any proof of corruption or evil motive?
I would agree with the counsel that if there was proof that a judge was actually corrupt, that then a judge could be liable. Here, the Judge Myers submitted it to the jury, the judge's immunity along with the policeman's immunity.
Well, now let's assume for the moment that a judge deliberately convicts someone when he knows there is no evidence whatsoever.
I presume that if you could prove that, Your Honor, that I believe that they would be liable if there was no evidence and he did it deliberately with the intent to hurt that person. Now, if he were mistaken...
So you and Mr. Racklin essentially agree on what the law says?
Except to the extent to which that has got to be proved, I don't, in my own heart, do not feel that judges should be submitted to suits. It would have to be so clear that before they should be submitted to having to defend themselves, the proof would have to be so clear. Here, Judge Myers thought that he would let it go to the jury, and he did with a verdict for the defendant. The Court of Appeals of the Fifth Circuit said there was no evidence whatsoever, and that it's against the judge, and it should have been dismissed.
May I ask, Mr. Grayson, under what instructions did Judge Myers send it to the jury?
There's no question of the instructions not being proper.
No, I just wondered, what were the instructions?
Now that I can't tell you about them without the record is long, and I don't recall the exact wording of them. But there's been no question raised on either side.
No, but I wondered, did Judge Myers submit it under some instruction that if the defendant judge were found guilty of corrupt or vicious or something like that?
If you are, please, I'm going to have to beg off on that one because I don't recall how that instruction was worded or just how he submitted it.
Is the instruction in the record?
But when it went, yes, sir, it's in the record. But when it went to the Fifth Circuit said there was no evidence whatsoever against Judge Spencer, and therefore that his suit should have been dismissed on the motion which was made after the conclusion of the evidence. I'll please briefly on the facts now, recalling that this is 1961, that the Freedom Riders had the violence in Alabama just 2 months before, that just a month before this occurred, there had been Freedom Riders in Jackson, and they had caused almost violence at that time. The coming of this group...
Miss Grayson, just let me pursue this other question just a moment. Let's assume a judge says, well, I agree that the Supreme Court of the United States has decided a case in a certain way, and that case applies to this case, but I think the Supreme Court is wrong, and I'm not going to follow the Supreme Court.
Oh, well, no, sir. I would say there was no liability whatsoever. That's a matter of judgment and a matter of his interpretation of the law.
So that isn't what you're saying.
No, sir.
So he might deliberately decide to deprive a man of constitutional rights, but that wouldn't make him liable.
No, sir. Not unless he was doing it corruptly. The illustration that Mr. Rocklin used would be perfect, where he got together the night before and conspired with one side and said, I'm going to deliberately decide for you and throw the book at him. Now, that might be corrupt, but not a judge differing with the Supreme Court of the United States or any other court I think is corrupt.
What if the judge says, well, I know the Civil Rights Act of 1964 requires equal service and public accommodation.
Yes. No, I would say not.
And I know that the owner of that the public accommodations refused service. And the judge says, but I just don't agree with that statute, and I'm not going to.
No, sir. I would say that that was his honest conviction of what the law was.
Well, no, he says, I know what the law is, I just won't follow it.
Well,
here's the statute. I know that
you're getting a little deep Please, that's a rather serious question that is not presented here whatsoever. This statute not only has never been held unconstitutional yet under which they acted, under which they were arrested, but the Supreme Court of Mississippi, 2 years after Judge Spencer's decision, affirmed similar cases and made exactly the same decision. So you couldn't possibly say here that there was any. I know what the law is. The law was valid on its face under which they were arrested. These policemen, these practitioners in their garb, in their church garb, mixed group, broadcast the fact and planned deliberately to come down to Jackson, Mississippi and to be arrested so they could be what they call witnesses of incarceration and go to Detroit as be witnesses. They came to be arrested. They broadcasted over television, newspapers, of what they were going to do. They came down in a drove in taxis to the bus station and went in. Now the opposing counsel has not given you the testimony on the other side. They went in and there is testimony that 30 to 40 people followed them in, that they had angry expressions, that they were muttering, and that they followed them into the bus station. This group of churchmen turned in to the left and started towards the restaurant, and the police, two just beat policemen on the street, told them to move on. They turned back and instead of moving, blocked the stairway in the bus station, stood in this narrow hall, and something the jury didn't need to be told was that that bus station is a very small room, and proceeded to recite the Lord's Prayer. There was a crowd. Not only had 30 or 40 followed them in, but they had there was a crowd in the station. There was muttering, mumbling, wrongful, violent gestures, until all three, Mr. Ray and the other two policemen, testified emphatically that they thought that violence was about to ensue and that it would ensue if they did not arrest them. Now, this is not a criminal case on which the criminal convictions would be involved, which would be decided on different principles of law and different bases of proof, where you'd have to prove guilt of such a crime or breach of the peace beyond reasonable doubt. This is a case where the only proof necessary is did those simple policemen standing there on that day with that going on, believing and assuming their own testimony to be true for the matter of this argument, have probable cause to believe that violence was going to ensue.
Mr. Grayson, where will we find in the record their statement that they were coming to Jackson for the purpose of being arrested?
Please, I'll have to find it. In my brief, I refer to there are a long group of directives or letters which were written to the whole group before they came, in which they were told what they were going to do and how they were going to do it. And those letters go from page 224 on for the next 50 pages. These original letters to these clergymen, to which they said that they were planning which one should go to jail. And at first they said, we think we'll consign 15 to jail and let the rest go on and be with and tell about up there in Detroit what happened. Then in another letter they said, we think now it's the better part of valor to consign only 12 men to jail. And then they told in these letters, you must stay there long enough without getting bail, because you wouldn't be a proper witness of incarceration if you didn't stay there a little while. And it runs from about page 224 of the record on. It came from these letters.
Mr. Grayson, I beg your pardon.
Yes, sir.
Do you agree that or do you think that the complaint here stated cause of action?
Yes, sir. There's been no question raised for
No
what the
question
complaint
raised about that.
stated the cause of action. We went to
Because
trial on
you
the
think
case.
that the complaint alleges the necessary intent or will or attitude on the part of the judge and the policeman?
Well, no question was raised about it. At the conclusion of the plaintiff's testimony, there was a motion to dismiss as to the judge file, which Judge Mines overruled. And that's what the Fifth Circuit said should have been sustained, because no evidence. But there was no objection made to the complaint, or no objection made to the jurisdiction of the court whatsoever.
Well, I must say that reading the complaint, I haven't yet been able to find the allegations with respect to intent.
No, sir. They are not. But we did not raise the point that the complaint, of course, they sued them all jointly to begin with. The judge could have filed a separate motion, I guess, to dismiss the complaint as to him, but as I recall, no such motion was filed.
Do you concede that a complaint which does not allege a vicious intent or purpose on the part of the judge or the policeman states a cause of action under the statute?
No, sir, I do not think it does.
But you nevertheless did not file a motion to...
There was no motion filed until after the conclusion of their evidence to dismiss as to the judge. And may I now state what occurred when they went before the judge. Here was a breach of the peace statute, unlike the South Carolina statute, unlike the Louisiana statute, not vague and indefinite, valid on its face. At that time, the law was final and Canterbury, I believe it is, Cantwell. Those were the two decisions of this court which upheld the Constitution. The final statute was identical with Mississippi statute. It was not unconstitutional on its face. It had never been held unconstitutional and has never to this day been held unconstitutional, although they insist on referring to it as an unconstitutional statute. It may have been at times unconstitutionally enforced, but never unconstitutional per se. They were brought before Judge Spencer, and he is an ex officio justice of the peace and municipal criminal court, a small city court, criminal court. It's part-time job. He was not a brilliantly trained lawyer. If he was, as I say, the Supreme Court of Mississippi 2 years later upheld the statute and upheld convictions under it. The cases came for trial. All of these petitioners were represented by two attorneys, and I think Mr. Rockland was one of them. There were two, I'm sure, but I think Mr. Rockland was one of them. They had attorneys in court. They could have had a jury trial. They did not request it. They did not testify in their own behalf. The policeman testified, and these petitioners sat mute. Well, what do you expect a judge to do with a valid statute, the policeman saying he was disobeyed, and the defendants not saying a word? It patently didn't suit their purpose to be let off at that time. They wanted to be witnesses of incarceration, and if the judge had let them off at that moment, they wouldn't have been. Then they went on later to the appeal to Judge Moore, and I beg to differ with opposing counsel the fact that the judge said that there was no evidence. The only thing in this record is a record of dismissal with no ground given for it whatsoever, just dismissed. It could have been dismissed on interpretation of the law. It could have been dismissed on insufficient evidence, or as petitioners themselves complained in their letters, they resented the fact that Judge Moore dismissed it because they were Episcopal preachers. They didn't want it dismissed on that ground. So the mere fact that they were acquitted later is apparently what they are saying shows corruption on the part of Judge Spencer. Just briefly further on the immunity of judges. In this Tenney versus Brandhold, this court went thoroughly into the legislative history of 1983, went very learnedly into it, and came to the conclusion that there was nothing in the legislative history of 1983 to show any intent on the part of Congress to change the common law liability of the tort, to make it anything except a common law tort. I would not purport to attempt to go into the history of that congressional act in 1871 to the extent that Tenney versus Brandhold did. But the basis of the end of their testimony, of their decision as to the legislative history was there was no intent to change common law tort liability. And, of course, the common law tort liability of legislators was immunity. Just as strong is the common law tort immunity, liability immunity of judges. That goes back to Bradley versus Fisher in 80 U.S. 335, where there's a remarkable decision on the necessity for and the reason for and the common law immunity of judges.
Bradley and Fisher wasn't a constitutional decision, was it, Mr. Pierson? I mean, the immunity there was not resting on the Constitution.
No, sir, I don't think so. I don't recall that it was a constitutional question.
Common law immunity.
It was a common law immunity. That's
So
what I say.
that-
Tenney versus Bradhope goes back to the common law immunity of legislators. The later cases in every circuit that has passed on it, except the Fifth, including the Fifth Circuit, have held that the same reasoning showed that the legislature's intent was not to change the common law immunity of judges. And there's no reason why it should be, that the intent was not to change the common law tort liability.
I mean, under 1983,
Yes.
Congress had no such purpose.
Had no such purpose.
Well, what about this language to which Mr. Rockland has referred us in the legislative history of the Senate version
He
of the earlier act?
has picked scattered passages from the congressional record. I say that if Tenney versus Bradhope went into it thoroughly, and they said there was nothing in the act to indicate any intent to change the common law, that the legislative common law immunity was old, well, so is the judicial common law immunity, and that's the reason I mentioned Bradley versus Fisher, because it is the leading case on the common law immunity of the judges. Since then, every circuit that has passed on it, the first, the second, the third, the fifth, the sixth, the seventh, and the eighth, have all held that Tenney versus Bradhope applies to judges. And so we don't need to argue here whether it needs to be complete, absolute immunity or just partial limited immunity, because there was no testimony in this record whatsoever that the judge had ever heard of these people before, that they just appeared in his court, that he had no conversation with any of the policemen about them or anybody about them, that he had any connection with them or any intent whatsoever, or any corrupt intent on his part. So we don't even need absolute immunity in this case. And I would like to hurry on to the immunity of policemen.
I ask you this question. Do you read Tenney versus Bradhope as meaning that there is no liability because there's no corruption shown?
As I recall, the case did not discuss the issue of if there was actual corruption. Now, when I say I admit that if there was actual corruption, I mean actual.
Yes.
I don't think that entered into that case any more than it does here. I don't think there was any question.
But a while ago you said that you agreed with counsel that if he had done this thing corruptly, the judge would have been liable. Now, do you read Tenney versus Bradhope to mean that if Tenney had been corrupt in what he did, that he would have been liable?
If you honor, please, I read Tenney versus Bradhope as merely saying there was no intent to change the common law. Now, if you go back to the common law of judicial immunity, don't you find that exception? If there's actual corruption.
Do we?
I think that would go back to the common law.
Yes.
And all Tenney versus Bradhope was saying was that we don't think that the legislative Congress intended to change the common law.
So it depends on what the construction of the common law was.
Yes, sir. I think that is the test, is what the construction of the common law was.
And you suggest that the judicial immunity, at least, the common law made an exception to that immunity in cases of the corrupt judge.
I think that it did. I have never felt there was any thought of any corruption in this case, and have not carefully briefed that question, because there's never.
About the Tenney and
Yes,
Bradhope.
Mr.
I was
Mayor.
in that case. I never had any remote idea until you suggested that there was a word that could lead to the impression that a legislator making a speech, working in the legislative body, could be sued about showing that he was corrupt.
Well, that because you would know better than I do. I don't recall that it was
I'm just
discussed.
not familiar with anything in it meant that or said it.
Yes, that's what my impression was, that it was not involved, that it was not discussed whatsoever.
What the hell was is his immunity.
Absolute immunity.
That's right.
Even though
Absolutely.
corruption. I have no fault to find with the court if they feel that way. I feel better about my client, Judge Spencer. I just had always thought that if there was actual corruption, that the immunity might not go that far.
Even though it did for legislators at common law.
No, sir.
You never thought that it did for judges at common law, or always an exception.
No, sir. I would think that any immunity would
You're leaning
disappear.
a little bit on the side of the dissent in the Terry case then.
In the what? I didn't understand you, Mr.
I'm talking about my dissent in the Terry case. Sounds like you're proving.
Leaning that way. But I do say that all the question of corruptness is beside the issue. In this case, we don't have to go that far. We don't have to go whether there be any actual corruptness, because there was none. There wasn't any evidence of anything except the judge giving his best judgment. Which I'd like to get to the immunity of the police officers, because if there's anyone that I feel stand here that needs representation and that I would like to do my best to represent, it is the policeman on the beat in these troubled times. When he doesn't know what to do, he has to make snap decisions. He has no lawyer running along his side to tell him what the law is or what the facts are, or whether he's right. He can't remember afterwards. Take all this occurred in this past summer, the thousands of arrests where policemen have arrested people, where they have thought at the time that they were justified. Suppose one of those men 3 years later says, well, I was acquitted. The policeman doesn't remember him. He hasn't got down and gotten witnesses and getting names, getting ready for a lawsuit 3 or 4 years from now. He doesn't know what the fine points of the law. He's got to use his best judgment in whether or not there's violence about to occur. And that is what we submit. That is the common law immunity of police officers. It goes as far back as the immunity of judges. If they have reasonable grounds to believe that there's probable cause of violence, then under the common law breach of the peace, they have a right to make an arrest without a warrant. In other words, probable cause is a complete defense to a police officer for a suit for damages at common law. There's no change under 1983.
Is for a suit for false arrest or...
False arrest, yes.
Yes.
Well, that would be true under Monroe versus Pate, too, wouldn't it?
Certainly Monroe versus Pate does not say, it doesn't say to the contrary. It has nothing to do with this case because that was a search and seizure case. And under a search and seizure case, there is no defense of probable cause. They searched the man's house, not in good faith, and also searched it
without a warrant.
Without a warrant. And for a false imprisonment case, probable cause on the part of the police officer is a complete defense. In an illegal search without a prior arrest, probable cause is no defense whatsoever. When that case was remanded, it was only before this court because the complaint had been dismissed as not stating a cause of action. And this court merely said that it stated a cause of action and remanded it, which I don't think any complaint came any nearer stating a cause of action than that, but any more completely stated a cause of action than that one did. This cause remanded it, and they resulted in the district court in a jury verdict for the plaintiff. And then the defendants, on a motion for judgment notwithstanding, brought up that there was probable cause for the search. And the district court dismissed it and said that probable cause is no defense whatsoever to an illegal search because of the constitutional provision, and that therefore there was no defense whatsoever to that cause. There's been no change in that common law rule any more than the immunity of judges in the under 1983.
On this point, you disagree with the Court of Appeals, don't you?
This is the point on which we petitioned cross appeal,
Right.
cross certiorari, on the ground that the Fifth Circuit held that probable cause was a defense to the common law cause of false imprisonment,
But not to the
was
1983 action.
not to 1983. In the opinion, they merely said that the rule may be otherwise under 1983, and cited no case which has held that it's different under 1983, and yet held that under 1983 probable cause was no defense. And because when this case goes back, we should have a right to submit to that jury again the issue of whether or not those police officers, because the common law controls and still is effective just as much as to police officers under 1983 as it would be to judicial officers. Monroe said that the 1983 must be read in the light of the common law of tort liability. It has not in any way changed the common law of what the tort is that they can be sued for. And in this instance, it was false imprisonment. I don't think this court is in any doubt, and it's thoroughly briefed, that false imprisonment is a complete defense at common law. I mean, that probable cause is a complete defense at common law. All that the Fifth Circuit said to support their decision was that inherent in the Monroe holding is the principle that good faith and reliance upon a state statute subsequently declared invalid are not valid as the defense is. I do not have time to point out to you all that our breach of the peace statute has never been held unconstitutional. This court, at the time this occurred, the rule was infirma, and which was held constitutional. In Thomas v. State, 2 years after this occurrence, the Supreme Court of Mississippi held it valid. This is unlike Edwards v. South Carolina or Cox v. Louisiana, where this court held that the statute was vague because it said that breach of the peace could include such things as disrest or disquiet or vague general words. In Mississippi and Thomas v. State, they held it meant violence, that a breach of the peace required violence. And that's what the proof in this case showed that the police officers believed. But even if this court should now hold...
I thought this case showed there was no violence.
That violence was imminent. Our statute permits a breach of the peace...
Not actual violence, just a possibility of violence, imminent violence.
Under such circumstances that a breach of the peace or violence, as our court has interpreted it, can may occur, is the language of the statute. But even if this court should now, 6 years later or 5 years later, hold the statute unconstitutional, which I don't think it will, it's not even pled. They didn't plead that it was unconstitutional statute. The rule in Mississippi and the rule in most places is that an unconstitutional law is a nullity, cannot be applied to work hardship to impose liability on a public officer who in the performance of his duty was acting in good faith in reliance on the validity of a statute before any court has decided it invalid. Mississippi follows that rule. Most of the, in fact, if not all other rules, note that as an exception, that a public officer cannot be held. There's a difference between the Ham case, where you say a conviction can be handed down, and the opposite here, where you can't impose liability on someone which was legal when they did it, and then come along 6 years later and say, no, we're going to make that was a constitutional statute then, but we're going to make it illegal now. I do not have time to go into the point on that petition, that plan, but that is not just a defense. They're planning to come and not just anticipating they might be arrested, but planning to come. That is not a mere defense, like assumption of risk, as opposing counsel would have you believe. It's inherent in the tort itself. There is no false imprisonment if there was consent, just as there's no rape if there was consent, there's no assault if there's consent. There are certain torts that where there is consent, there is no tort to begin with. So it's different from a defense. I would like to urge...
You may complete that statement that you were just going to make.
I urge the court to give this case serious consideration because of its importance in the future litigation of thousands of cases in the federal court and on the effect it will have on our police force all over the country if they are subject to suit and subject to money damages with little pay and families, and if they are subject upon to suits for damages, it can have a disastrous effect on the protection of the public.
Mrs. Grayson, may I ask this last question?
Yes, sir.
Are you asking us to reconsider Monroe and Pate?
Oh, no, sir. I said my position is it has nothing to do with this case whatsoever.
Well, the Court of Appeals relied heavily on Monroe and
Yes,
Pate.
sir, and I think they thoroughly misunderstood it. It was a search and seizure case where probable cause was no defense whatsoever.
Well, as I read their opinion, they rely on Monroe and Pate for saying that good faith is irrelevant.
Yes.
If, in fact, the color of the state statute, which they thought was valid.
They said it's inherent in Monroe versus Pate that the good faith under a state statute, I'm talking about actions under 1983 only, was immaterial. Monroe versus Pate didn't even deal with acting under a state statute in good faith, believing it was to be valid. There they were acting without any, contrary to the state
then your
statute.
answer to me is you don't want us to reconsider it, just to say that the Fifth Circuit misapplied.
Misapplied it. It didn't have anything to do with acting under a state statute, which was later declared unconstitutional. They were acting without statute, contrary to the state statute.
And by definition, the search and seizure in Monroe against Pate could only be illegal if there was no probable cause, and there was therefore a finding when damages were found that there was no probable cause, and that took that defense away, isn't that the point?
Yes.
Would you
The
mind,
circuit took it away.
excuse me,
Yes, Mr.
would you mind telling me in a sentence just what is the question the state presents in its petition for such a rule?
Well, the state is not here.
Well,
You mean the petition? The one error of the court below in saying that the probable cause is not a defense to false imprisonment under 1983. They said it was a defense under common law, but they held it was not a defense under 1983. We submit with no justification for such a distinction. Yes. So.
Yes. In other words, if this is to go back to new trial against the officer, as I read the Court of Appeals, the only factual issue is going to be consent or invitation.
Yes.
And you suggest that there has to be an addition, or perhaps
they have
a reversal and affirmance of the district court verdict on the ground that the issue of probable cause
that will be a defense
in the case and properly submitted to the jury.
Yes, or will be submitted to a new jury.
If there is to be a new trial.
On a new trial.
Well, even under your position, there has to be a new trial because there were errors of evidence.
Well, in our brief, we have said that we thought the Fifth Circuit differed on erred in saying that those were errors in the evidence. But I have not had time to argue. They were just small matters of evidence.